Welcome, Springfield, to the second half of the show. We have a guest on the show now, and George Patrick is an attorney from Indiana, practices in northern Indiana, up by where I went to law school. He went to law school, Valparaiso, Indiana, School of Law, so he must be a good guy. George, I want to thank you for being on.
Oh, thank you very much for inviting me today.
And I see you literally wrote the book on workers' comp in Indiana, the handbook. Is that right?
We have participated with several of them and put out a number, but I only write them for one side of the fence. I only represent injured employees. I don't represent the Chamber of Commerce or the Manufacturers Association.
Right, but I mean, there's a handbook that you printed out for that I took I thought it was kind of interesting. So, I mean, anyway, you limit your practice to workers' comp for the petitioner, correct?
Yes, we represent injured employees north of Indianapolis 6 days a week. I actually just got done with phone calls this morning.
All right. Well, I want to thank you for being on the air. Why don't you tell the people in the audience just basically what you guys have in Indiana, and maybe we can kind of compare.
Well, Indiana's system is a system that has been ranked nationally to be the fourth thriftiest system for delivering statutory benefits. So from a big picture point of view, as you compare Indiana and Illinois next to each other, Indiana has 92 counties. We're not quite as big geographically as Illinois, but almost. And we have 7 workers' compensation judges for all 92 counties. And so with that, we have all these counties where a judge comes and listens to your workers' compensation claim. It is a fairly informal process. It was designed to be fairly quick. Each of our workers' compensation judges is assigned somewhere between 3,000 and 4,000 claims per year. So it's their job to march through those effectively and efficiently.
So what is the injured worker entitled to get?
In Indiana, different than Illinois, in Indiana we have 3 statutory benefits that the judge is allowed to award. There is this idea that there needs to be a replacement for your paycheck when you're unable to go to work, and so it's either temporary total disability or temporary partial disability if you're able to work light duty or in some other fashion so you're not completely off of work. In Indiana, that's capped at 2/3 of your weekly pay, but that's a fiction, if you will, because even though we say 2/3 of your pay, the idea is that we want to make it approximately the same as your net, but we put a cap in Indiana that's much lower than Illinois, and so currently the effective July 1 of 2014, the amount is $693 a week that an injured employee and their family receives tax-free from the workers' compensation insurance companies. Before that, it used to be $650 a week.
Yeah, I looked at the web. I thought it was going to be. I thought you were going to say 650 is what it said on the information I got. So, and that applies if they make $100,000 a year. They're getting $690 a week, $693.
Yes, and now the good thing about Indiana is, in the right circumstance, if your weekly check happens to get you less than $600 a week and you're a union employee, we've been successful at using the other fringe benefits that are part of your collective bargaining agreement to argue that there's a provision of the Work Compact that says those are benefits paid on your behalf in lieu of or instead of benefits. And so we're able to use those fringe benefits to argue that those should be included in the calculation, and many times that then raises the injured union employee up to at least the max rate.
Up to the $693?
$693. If for some reason they happen to be a little below, we use that so that
get them up a little bit.
We can get them up a little bit, and we're getting the max that we can get them.
Do you get minimums too?
We do. We have a minimum, and unfortunately, every now and then people ask me how it is that I run into the minimums. The most typical place that you wouldn't expect to see a minimum is my part-time school workers. And by that I mean the cafeteria workers are often not considered full-time. And so those folks, even though they work 5 days a week, make a little bit more than minimum wage, but not very much. And so we have a minimum threshold in Indiana of $75 a week for temporary total disability benefits, and a minimum threshold for permanent total disability cases of $75,000 a year. Or I said that wrong. I apologize. $75,000 for a minimum permanent total disability claim for 10 years. And
isn't that the max you can get? I mean, aren't you capped at? Isn't the perm total payout capped at basically 10 years?
It is. Indiana is one of the few states left where after 10 years you're eligible to apply to a fund that was created after World War II to help encourage employers to hire veterans, called the Second Injury Fund. And you're eligible to apply for that. You may or may not qualify. And so usually we tell people all you can count on is 10 years worth of benefits. You may or may not qualify for this additional extension, if you will.
And that's even if they're stuck in a wheelchair and can't do anything together. I mean, they're stuck at that, right?
Yes. In Indiana, you're absolutely right. Our definition of permanent total disability is there's no job you can do, part-time, full-time, with benefits, without benefits. Indiana doesn't have any recognition, as Illinois does, that you used to earn $30 an hour and now you earn $10 an hour. In Indiana, our workers' compensation judges have no way of awarding to the injured employee that loss of income.
Yeah, I was going to get to that. So we call that a wage loss differential for the people involved. And so, and that's honestly, those are the kind of the numbers that are pretty common in union workers around here. We get guys that are making around $30 an hour in a union, getting in some kind of a work injury, and no longer can go back to their heavy physical job, and they end up with, frequently somewhere in the $10 an hour range. And that's a lot of workers' comp. I mean, we get a lot of those cases. What do you do in those cases?
Those cases are horrible in Indiana because you have what I usually consider fairly young workers, workers that are somewhere between 35 and 50, facing the prospect that they haven't worked long enough to be fully vested in their union benefits, facing the prospect that they are unable to return to basically any union employment that we have, because the union employment that they were doing wasn't an office job or a sitting job by any stretch of the imagination. And so in Indiana, we have one agency called the Vocational Rehabilitation Agency that's a state-run agency that tries to help, but there's nothing our workers' compensation judges can really award or give that person who has lost that good-paying union job with benefits and now may be only able to work a part-time job without benefits. There's no remedy, or there's nothing the work comp judge can award or help do in that situation. They're basically pushed onto the benefits programs within the state of Indiana to pick up, and insurance companies
so the taxpayer
to avoid that.
Taxpayer picks it up, or the injury victim picks it up, basically.
Yes.
Yeah, I mean, and that's a huge loss to these people, because I mean, at $20 an hour, you figure that's $800 a week. That's over $30,000 a year. 10 years, that's $300,000. And that's just 10 years.
And that doesn't include, the loss to the families of their health insurance benefits, the loss to the families of these other. And there's just no way currently in our system in Indiana that our judges have any ability to even consider that.
Yeah, we get wage loss differentials here, and the people are entitled to 2/3 of the loss. They have their caps on it, and and you got to deal with that. But still, it is it's more favorable for the injured worker. I think it's fair to say. Medical, you guys, how does your medical work?
That is probably the singular number one legislative item that I continue to try to change year after year.
Go ahead, I'm sorry.
The shock in Indiana is, for the first time, when people have a workers' compensation claim, they realize that they're required to go to the physicians approved and chosen only by the insurance companies.
And what does that mean for the injured worker?
Many times, injured workers become frustrated if they're not a trauma case where they're not bleeding and there's not bone sticking out. They often first get shuttled to an occupational health clinic that has been carefully trained, screened, and vetted, because in Indiana, you can be off work completely 7 days, and there's no obligation by the workers' compensation insurance company to pay you those first 7 days until you've missed 21 consecutive days. So they take people off work 7 days, give them painkillers, start them on some physical therapy, usually return them to work in some light-duty fashion, and they sit in this limbo situation, depending on how long they want to put up with it, for the next 3 to 6 months. Sometimes the occupational health clinics are making recommendations that the injured employee be seen by a orthopedic specialist or some type of other specialist, and the insurance companies basically just ignore it.
Ignore the treating doctor, the orthopedic specialist, you mean?
Well, ignore the occupational health clinic's recommendations even to get to an orthopedic specialist. And so many people at that point, Jim, simply drop out. I'm done pursuing my workers' comp claim. I have health insurance. I'm going to use my health insurance to go get this done. And they drop out of the system. And then what happens is they go see an orthopedic doctor, and they've been told by the claims adjusters, by the nurse case managers, that you have to see our doctors or we won't pay for it. So they simply don't tell the next physician, I got hurt at work. And so then the medical
rep... Then they get more reasonable treatment?
Usually what happens is they get diagnostic tests, and the diagnostic tests come back, and suddenly there's a surgical recommendation, and then a much more, and they take that to their employer and say, I need to be off work. I have this
surgical problem.
The employer sometimes says, well, wait a minute, time out. Why is our insurance company not paying for it? Because many times the employers are simply left out of the loop, and then suddenly the tug of war where I become involved is the employer tells the second non-approved treating physician, wait a minute, you recommending surgery, our person got hurt at work, and then the second physician says, oh, I didn't know they got hurt at work, and then you just have a train wreck that it takes a while to sort out. And that's many times when I become involved in this case, and the injured employee explains to the judge, I went 4 months to the occupational health clinic and nothing was happening.
And so then what happens to their claim? Are they out of luck on the claim, or what? Do they still have a right to pursue it?
They have a right to pursue it, but at that point, now they're very frustrated because work says, well, the second doctor has taken you off work for a surgical recommendation. The insurance company, the workers' comp insurance company says, well, that wasn't our doctor, so we're not going to pay you temporary total disability benefits either until you agree to see our doctor or until our doctor looks at you. And so all of a sudden this person is simply starving and looks at me and says, no income, what do I do? And that's when, that's when we really have to start to hurry to help these folks because they're simply drowning.
Do you find that the doctors that are picked by the insurance companies are reasonable?
The problem in Indiana is because the physicians are picked by the workers' compensation insurance companies, the insurance companies tend to try to pick physicians who are willing to minimize and reduce the time off and the amount of care as quickly as possible for injured employees so that they can basically save money for the workers' compensation insurance companies. It's a frustrating process. We've made headway because as soon as the treating doctor in Indiana releases you, the insurance company is required to send a form giving the injured employee a right to a second opinion for a physician chosen by the Workers' Compensation Board this time.
All right. A guy called up. I'm going to ask you a question before we get too much farther. A guy called up earlier in the show and said he's not going to be able to tune in for the second half of the show, but he wanted to know if you know how much of the difference in the cost of the workers' comp system, it varies by geographical region. In other words, how much of it is due to the fact that, you're in Chicago versus Indianapolis. Do you know the answer to
that? In terms of the medical costs?
I think he meant in general.
We have studied the geo-zip code medical costs, and the medical costs between Indiana and Illinois are not significant. Whether it be Chicago or Indianapolis, the variation is less than 10%. And so from that point of view, we have argued in Indiana that we should be allowed to pick our physicians, because when you look across the border at Illinois, we can prove that a state that allows employee choice of physician, the medical costs are not dramatically higher.
What about the the payout costs? For instance, TTD, what we call permanent partial disability. In other words, your scheduled award at the end.
In Indiana, we're very different than Illinois. We use a very strict system that applies the American Medical Association Guides to Impairment. It's a book that started a number of years ago. It's now in its 6th edition. And it is the only mechanism that the work comp judge can award damage to the employee. The easy one is always, of course, the amputation. You look down, the injured employee is missing a finger, missing an arm. That's easy. The difficult ones are a back surgery, a shoulder surgery, a knee surgery, because that focuses on range of motion and strength. There's no consideration in Indiana as to how that injury allows or doesn't allow you to do their job. And so the judge simply looks and says, well, the treating doctor says that after your back surgery, now you can only reach your knees. You used to be able to bend over and touch your toes. I, the treating doctor, grading my own work, say that's worth 5% of a whole person in considering the American Medical Association Guides to Impairment. And so the injured employee then should receive a settlement offer from the Workers' Compensation Insurance Company of $7,000.
That's for a back surgery?
That's for a back surgery. If the injured employee doesn't agree with that, the injured employee has a right to go get their own rating. And so if the doctor looks and says, gosh, instead of a 5, I think it should be a 10 in Indiana, then the discussion turns on, well, our doctor's rating is worth $14,000, and you haggle back and forth, or you have a hearing. And the judge is presented with these two different competing reports and gets to decide how to resolve it.
That sounds almost like, that's a back surgery. That's a pretty serious case. I would think there's an awful lot of cases that are completely unviable from an economic standpoint. Is that
it becomes difficult. It's a difficult discussion to have with an injured employee whose employment has been significantly reduced or, in fact, completely eliminated. Say a union electrician with a rotator cuff tear. And so suddenly they're told, you can work, but you cannot do any overhead work whatsoever. And so you can't reach above your head with your two hands. And they look and they say, but I've been a union electrician now 14 years. I'm completely out of my trade or completely out of my craft. What am I going to do? And this judge is confronted with this situation. And so those become very difficult discussions to have with these people, because you say to them, look, number one, the judge has to process 3,000 or 4,000 claims. Number two, you're not permanently totally disabled. Number three, you're going to need to get another report. It's going to cost you $1,000. They've offered you $6,000, $8,000, $10,000. Your report's going to cost $1,000. The most I think I can get you is $18,000. And then of that, you're going to pay me, the attorney fees in Indiana, are 20%. Those become difficult for injured employees. Become very angry.
I bet.
It's difficult to explain to them that how this system was designed in the early 1900s is not how it's intended to run today.
George, I'm really enjoying talking to you. I wish I could talk to you for another half hour, to tell you the truth, but we're out of time. I want to thank you for being on. I really enjoyed talking to you today, and I got to talk to you a little bit yesterday about all this stuff. It was fascinating, and maybe someday we can take it up again.
Sounds great. Thank you so much.
Thank you. I want to thank everybody for tuning in. Enjoy the beautiful day we're having, and hope you get down for the festivities downtown for the parade. And I'm Jim Ackerman. This is Let's Talk Law. We're about out of time here. How much time we got there, TJ?
15 seconds.
15 seconds. So I want to thank you all for tuning in one more time. We will be back next week with another show. We hope you enjoyed the show. I'm Jim Ackerman, and have a nice week. Bye.
News you can depend on. Start